5, 4, 3, 2, 1. Start. The matter before the authority pertains to a petition filed seeking appropriate directions against an administrative body for alleged non-compliance with procedural requirements. The petitioner has alleged that the respondent failed to discharge its statutory duties, resulting in the violation of the principles of natural justice and denial of fair opportunity. The respondent, on the other hand, has submitted a written reply denying all allegations and asserting that due process was followed in letter and spirit. It is contended by the petitioner that no prior notice was issued before the action was taken and no opportunity for personal hearing was granted. It is further argued that the impugned order suffers from non-application of mind and lacks any reasoning. The petitioner has also prayed for quashing of the said order and for issuance of an interim relief to maintain status quo until final adjudication. Per contra, learned counsel for the respondent submitted that the action taken was strictly in accordance with the procedure prescribed under the relevant rules, and that the petitioner was duly informed through public notification. It is also submitted that the petitioner had the opportunity to file objections but chose not to participate in the proceedings. Therefore, the principle of audi alteram partem cannot be invoked in this case. Having heard both sides and perused the documents placed on record, it is evident that the core issue involves procedural propriety and adherence to the doctrine of fairness. The right to be heard is a fundamental component of administrative adjudication. Even in cases involving urgent action, the authority is bound to record reasons and provide for post-decisional hearing wherever applicable. In this context, it becomes relevant to examine whether the order passed was a result of arbitrary exercise of power or if it was supported by sufficient material on record. Judicial review of administrative action is limited to examining legality, reasonableness, and procedural fairness. This forum cannot substitute its own views for that of the competent authority, but can intervene if the action is found to be perverse. The record shows that though a public notice was issued, there is no evidence to prove that individual intimation was served on the petitioner. The correspondence annexed does not indicate personal service or acknowledgement. Therefore, the argument that the petitioner was aware of the proceedings does not hold merit in the absence of documented proof. Moreover, the impugned order is cryptic and does not reflect any application of mind. It merely reproduces the statutory language without providing any reasons or findings. Such orders, devoid of reasoning, cannot withstand the test of judicial scrutiny. It is well settled that a quasi-judicial authority must record reasons for its conclusions, even if the statute does not expressly mandate it. It is also pertinent to mention that the petitioner approached the forum within a reasonable time and has not been guilty of delay or laches. The balance of convenience appears to be in favor of maintaining status quo till the matter is finally decided. No irreparable harm would be caused to the respondent if interim protection is granted at this stage. Accordingly, an interim order is passed directing both parties to maintain status quo in respect of the subject matter of the petition. The respondent is restrained from taking any coercive action till the next date of hearing. The petitioner is directed to file any additional documents or evidence within 7 working days. The respondent may file a detailed affidavit in reply within the same period. The matter shall be listed for final hearing on the next available date. The registry is directed to issue notices to all concerned parties and ensure proper service. Both parties are advised to maintain decorum and avoid unnecessary adjournments. In a related matter, it has been brought to the notice of this forum that several similar complaints have been received from other individuals, raising identical questions of law and fact. In view of this, the authority is considering clubbing of all such matters for simultaneous hearing, subject to objections from respective parties. A common issue note may be prepared and circulated for reference. The parties are also reminded of their obligation to act in good faith and extend full cooperation for early disposal. Frivolous applications and technical objections aimed at delaying proceedings shall not be entertained. Costs may be imposed in appropriate cases to discourage abuse of process. It is further clarified that any violation of this interim order shall be viewed seriously and necessary action may be taken for contempt of directive. The parties are expected to adhere strictly to the directions issued herein and report compliance on the next date. Separately, a note has been received from the administrative wing regarding delay in submission of compliance reports in previously decided matters. All concerned departments are hereby directed to ensure timely submission of action-taken reports in prescribed format. Repeated failure to submit compliance may invite disciplinary action. The legal division is also directed to compile a status report of pending matters and categorize them based on urgency, complexity, and nature of relief sought. A meeting of all legal officers shall be convened to review backlog and prepare a roadmap for expedited hearings. It has also been observed that replies are filed without verification or with missing enclosures. Going forward, it is mandatory to include a verification certificate along with every reply or affidavit filed before the forum. Any incomplete or unsigned documents shall be summarily rejected. To enhance efficiency in legal proceedings, steps are being taken to standardize formats for notices, orders, and affidavits. Draft templates will be circulated shortly, and all future filings must conform to the prescribed format to avoid procedural objections. In conclusion, the principles of equity, justice, and good conscience must guide all decisions. The forum reiterates its commitment to fair and impartial adjudication of all matters. The parties are expected to cooperate in the interest of justice and ensure timely disposal of cases. Let this order be communicated to both parties without delay. Stop.